from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shaw Pirelli for the Shaw Pirelli Law Show, coming at you with over 50,000 watts of power. The Shaw Pirelli Law Show, where all your views matter.
Hello, everybody. Assalamualaikum, Sastakal, Namaskar to all the listeners. This is Attorney Shaw Pirelli for the Shaw Pirelli Law Show, and we are going to talk, of course, today about immigration law and some, of course, debt settlement, but mostly immigration law. So today I have with me my friend Michael on the board. Michael, I hope my voice is coming out clearly. And also, if you want to call, the studio number today is 510-657-1170, 510-657-1170. And also, if you have any questions, again, the number to the studio, 510-657-1170. And if you want a private consultation, 510-742-5887, 510-742-5887. So, ladies and gentlemen, today we're going to talk, of course, about immigration, and we are going to talk also a little bit about debt settlement. But first, I'm going to talk a little bit about updates on H4EAD. Well, there's not really much updates since I spoke last week, where we are waiting on those 90 days to get an idea. However, we are seeing a lot of things happening on the other front, and of course, we are seeing H2B has been opened. I don't really handle H2Bs, but they have added more H2Bs. This is only one good thing that has happened. And the rest, of course, there's a lot of speculations what will happen next. A lot of people are really fearing what is next. And what's happening out there is really heartbreaking, especially I mentioned that last week, there's kids that are being separated from their parents. And this is really, really sad, and most people are really upset about it. Not most, but many people are upset about it, but nothing is really kind of happening except it was determined by the United Nations that this is illegal under the charter, under the treaties that were signed by the U.S. However, having said that, and who's going to bring an action, we'll see. There are probably lawsuits. I think there is a lawsuit going on that. But again, there are so many fronts to fight that many people are kind of not knowing where to really start. So each group are fighting their own. One of the big questions I'm having on the H4EAD is, if H4EAD is set to be taken away, will there be a lawsuit? Well, that's going to be really hard to tell, because there are a few organizations out there which are willing to fight, but they themselves have a lot on their hands. So I think we should call on organizations to help on this. Although we have the support of so many Congress people, we also have, on the other side, not the support of the government. So when the H4EAD was passed, it was under Obama, and Obama was, since they passed it, they were fighting for it. But now, since it's under Trump, it's very, very different, because they're looking at it from the perspective of hire American, buy American. And according to them, it might seem that this is not in alignment to their needs and their decisions. So again, if you have questions, you don't have to limit yourself with H4EAD or related to employment base. You can also call us for other questions on immigration. Feel free, 510-657-1170. I think I have Abhishek online, right, Mike? Hi, Abhishek. Hi, Abhishek.
Hi, sir.
Hello. Hi, how are you, sir?
I'm doing good, sir. How are you?
I'm doing well. What can I do for you?
So I just wanted to ask you a question regarding adjustment of status interview.
Mm-hmm. Go ahead.
So the only doubt that I have right now is that during the interview process, they ask for a lot of documents from the interviewing officer does. So do we need to have all the original documents? As I'm in a situation that I lost some of my documents from my previous employer and my I-20s, but I do have the scanned copies for all of those documents.
Mm-hmm. For I-20s and things that comes from the government of America, copies might do. But any document that comes from another government, for example, a birth certificate, for example, a marriage certificate, so for example, anything that is outside really the U.S. parameters, you might want to have the original. But it's good to have the original, but if you don't have it, you can explain there that you lost that, but you still have a scanned copy, and that's what you're presenting. They should be able to trace it with the number. But the only time that it becomes a problem if they are not able to trace it, and that's a different issue, but that's not really a normal issue. But most of the time they don't ask for those. What they're asking stuff that comes from abroad. They want to make sure that you didn't kind of tamper with those documents. For example, a marriage certificate, a school record, a medical record from abroad. They will want to see the original. The reason is they want to make sure you have not given a fake copy. But if it is just a matter of an I-20, an I-94, and things like that, copies from your side is good enough.
Okay.
Hello? Okay.
Yeah.
Okay, good luck to you. When is your interview, by the way? Coming soon?
Yeah, I'm hoping to be getting it scheduled soon, yes.
Okay. If you need any help, call at the office, 510-742-5887. I don't know if we have another caller, Michael. Shapira, you're live in air? This is Shapira, you're live in air? Hello? Okay, so we don't have any caller, but feel free to call. A very good question we got today, because the interview is becoming part and parcel now of all the I-45, which was not there before. This has just been introduced. Mostly before, you will have an interview if the case had some issues or random check, or you had a criminal background. You had an interview for family-based, and usually for marriage, definitely, for parents once in a while, but now pretty much everything is going through an interview. So make sure you have all your documents ready, and make sure you also know, don't panic there. Just having an interview doesn't mean it's going to be denied. It's just something normal. You answer truthfully, you should be fine. So, ladies and gentlemen, we were talking about, of course, all the issues that we are saying, and one of them is the H-4 EAD. People are asking if there will be lawsuits, and well, if it goes away, I hope some people will step up, because you need a plaintiff to file that, etc., etc. And then let's hope that we will have a court kind of siding with the H-4 EADs. And at the same time, telling people, one of the things that I get a lot right now, what do I do next if the H-4 EAD is going to be taken away? Well, you need to, while the EAD is being taken away, the H-4 is still there. You can still stay in the U.S., but you might not be able to work. And my take on it is that you will still be able to continue using it until the dates on the EAD. So let us hope that I am right on that. I'm not wrong, and that will be at least protecting people until the next step. So now the other thing that I recommend people to do is to make sure that if you're filing also for an H-1B visa, you might want to make sure that your paperwork also is in order, because one of the things that we are seeing now is that unlawful presence that came on an OPT, and because of that unlawful presence, then you might be out of status once after August 9, when they're basically saying that, hey, if you work for a third party to the STEM OPT, it's not allowed. So what it will do automatically to you, it will put you kind of with the second memo which says unlawful presence, you might see a situation where you have a denial of your H-1B because your status got taken away, or an H-1B partial approval where you will have to, instead of getting a 797A, you will get a 797B. So you need to make sure that you are compliant with everything, especially if you're an OPT or some kind of other visa. So, ladies and gentlemen, this is Attorney Shapira and from the Shapira Law Group, and today we're discussing about immigration law on KLOK 1170 Radio Zindagi, and we have Michael on the board, and we're trying our best to kind of cover topics such as on all the topics, of course, immigration, but we also will try to kind of answer your questions as much as we can. Again, everything I'm telling you is not legal advice. All it is some informational things, and then If you want a legal advice, then you will have to go ahead, call our office, 510-742-5887. And again, today what I was saying is we are seeing a lot of issues coming up on the H-1B, because there will be some changes also that we are expecting on the specialty occupation. Right now, it's already a difficult issue, but you also have other issues that you can see here coming up, not only on the H-1B but on L-1 visa, etc., etc. That's why it is important to make sure that you get a good advice on the case before you move forward. Many attorneys have been practicing pretty much on an easy basis, because the problem is there was no problem. Now problems are starting, and they are finding themselves into situations where they don't know the answers. And even us, I'm not saying we know it all, because it's impossible to know it all, but at least we deal often with more difficult cases than easy ones. So we might be able at least to guide you through a consultation. And again, the studio line today is 510-657-1170. 657-1170. 510-657-1170. And we're talking, of course, about immigration law. And I was covering one topic, but there are so many other topics we can cover. And, of course, it all depends how many callers we get. Then I can take into different topics. I think we have another caller, right? Hi, Harpreet Shah. Hello.
Hey, Shah.
Hi, Harpreet.
Hey, Shah, I had a question regarding the H-1B denial due to specialty occupation.
Mm-hmm.
Yeah, so my H-1B got denied, and my company filed a P2 visa for me to legally stay in the U.S. And then they are planning to do a consular H-1B. So my question is, how as soon as the H-1B gets approved, then I have to go to India, or maybe I can go to Mexico or Canada to get the stamping done?
Okay. It depends. Did you have a stamp on your passport of H-1B before?
Yes. This is my post 6-year extension.
Okay. Then yes, you can go to Canada. Mexico, I'm not so sure, because sometimes they don't accept it there. But Canada, yes, but you will have to get a visa to get into Canada. So that's the only disagreement you have. Disagreement, I should put it, the kind of issue that you have. So yes, you can go to Canada. You can go. Mexico is not sure, so you need to double check with them, because sometimes they do it, sometimes they don't. But Canada, Jamaica, I don't know if Jamaica is doing, but other countries, yes, you can go. That's bottom line, because you had a stamp before. It's your second stamp or third stamp.
Okay. So what happens to the situation? Worst case, if I go to India to get my stamping, can I get a 221G RFC as well?
Yeah, 221G can come anytime, my friend. It's unfortunate. It's hard to tell, depending how strong is your case, or depending on the officer there. It's very hard to tell if you're working for a consulting company or just a regular.
No, just a regular solution.
So your chance
a product
of 221G is low, as long as the company puts you on the right job and the right level. You should be okay. But 221G is hard to tell if you will get or not. I'll say 30% of cases get 221G. Most of them don't. Okay.
Worst case, one more last question. Worst case, if it does, it gets denied, and I'm held back in India. So can I still keep working on from India for my company here?
Of course. Once you're outside, you can work even you don't have H-1B or not.
I see.
Because once you're outside, U.S. have no jurisdiction over you. You can work remotely from there, from India. Okay?
And coming back is also not a problem, right? Because my B2 visa would still be valid for another 6 months.
No. You have a B2 stamp on your passport?
No, not yet. But the company has already filed for a B2 visa.
No. What they file for you is a change of status. That, as soon as you leave, will get cut off. You will need to get another stamp to come back. Okay?
I see. Okay. All right. Got it.
Okay.
Thank you very
much. Good luck to you. Call me if you need help. 510-742-5887. I think we have a few other people. This is Shaprali. You're live on air.
First of all, thank you, sir, for sharing all the information. Really useful.
Thank you so
I have a question regarding my parents' visa appointment.
Mm-hmm.
So they had a tourist visa which expired last year, and now they are applying again. And based on the interview schedule, they asked them to go to fingerprinting. Without they have the visa waiver, they don't have to go for the personal interview. So my question is, when they go there for that interview, what documents they need to take, especially from my side?
Well, are you filing the I-134 for them, the affidavit of support?
Hello?
Yeah, are you filing the affidavit of support for them, I-134?
No, I'm not filing because according to the details, they are asking to carry only the documents for themselves, right? Passport, I-160, and bunch of other stuff.
Mm.
But do I need to provide those documents? Because that's not an interview. It's just a fingerprinting appointment kind of thing.
Yeah. Then you don't have to provide anything. You just give them those documents that they ask for you. That's all. Because they are just going for fingerprinting. They just want to have a proof that you have the appointment and plus the letter of the appointment. That's it. Okay?
Okay. So no supporting document from my side in that case, right?
No, because you don't have anything to do with it right now. So what would you support? There's nothing. Just bring what they tell you in the list, and that's it. Make sure you have all of it. Okay?
Okay. Thank you, sir.
Okay. Good luck to you. Let me take another caller. This is Shabra. You're 11 here.
Hi. Actually, I have a question.
Hi.
Like, my mom has green card. She got like 3 years ago. So since then, she's staying in India like for less than 180 days and rest of the time here in USA. But this time, like, she stayed more than 180 days in India. That is like 181 days. So my question is, does this break her continuity to apply for citizenship after she completes 5 years next year? So is she still eligible for applying citizenship next year?
Yeah, that's a case-by-case basis, but a very good question because definitely they probably will not take the green card, but the continuity is usually broken after the 180 days. However, there are exceptions to that rule. If there was some kind of emergency or didn't get the ticket or she was sick or things like that, then make sure you bring that with you if she has a doctor's appointment or she had some kind of surgery or she had some kind of person who was sick she had to attend to. Then the continuity can be resumed kind of if there's an exceptional circumstance. I had a case where 11 months, but her mother died, so she had to stay there. These are the kind of things you can use. But otherwise, if you look at the letter of the law, pretty much after the 180 days, yeah, there's a chance they will break the continuity. But it's a case by case. If 181 days, you might get away with it. So go ahead, file the citizenship, okay?
Okay, thank you.
Good luck to you. So, thank you so much. We had a lot of callers. Thank you, Michael. So, the lines are still open. The number to the studio is 510-657-1170. 510-657-1170. And we are talking about all the things happening in right now in immigration. Well, not all, because there's no way I can talk about all. There's so many things happening. But as much as I know from my side what we can advise you on, I'm trying my best to bring it to you today. And this is Attorney Shaparali from the Shaparali Law Group. Our website is attorneyonair.com, attorneyonair.com or piralilaw.com. So bottom line here, we have so many situations happening, and for one, we have those kids that are being separated from their parents. That's one thing. For those who are coming at the border, be very careful. Don't bring kids with you because it's really horrible what's happening there, and it's heartbreaking. But there's not much we can do until we get some kind of ruling on that. Now, the other thing that I was mentioning earlier, of course, is the H4 EAD, and unfortunately, we will know in the next, I'll say 70, 80 days left, now what will happen. But in the meantime, I wanted to let you know, just make sure if you have an H4 EAD, you can renew it please renew it. Another things I'm hearing also for some people, it seems like they're getting letters basically kind of delaying their H4. And God knows what is happening there, but I didn't get any of those cases. I cannot really tell. I just heard it. So let me take another caller. Is Harish on air? Hi, Harish. Hello. Hi, Harish.
Hey, Shah. Thank you very much for your show. We are very much learning from your show.
Oh, thank you so much for your kind words.
Hey, I have a question. This is a little bit weird, but so what happened is in India, initially I don't have a birth certificate, because of which I got 10th class registration as 80 as my birth year for my date of birth, and it continued in the passports, and even here also it continued as 80, and right now my green card I-140 was approved with same date of birth. But now when I went back for asking for my birth certificate, it looks like the government records as 81 as a day birth year. So I'm kind of confused. What are the options I have it right now, and what direction is the right direction to take legally as well as
the government? Since the government is saying 81, what you will need an affidavit basically to back that, and you will need to go ahead, change your passport. And then when you file your case, either I-45 or something, make sure you advise USCIS that this is not the right date, and put a declaration in there, because you need to correct that. If you don't, it will create problems down the road. So since you didn't know about it, it's not like you committed some fraud. It was unknowingly. So you need to just put a declaration under penalty of perjury that you had the wrong information. And you will need to prepare some paperwork, correct your passport, etc. As many things you can correct it. And then when you file anything next, you make sure that you mention this and you are upfront about it. Okay?
Okay. So is there any other government records do I need to change along with this one? Say, for example, my social security number records have
once you change that, you go to the Social Security office and ask them to update it. Your driver's license to update it. Everything you can change, go ahead and change it. Anything you cannot change, you cannot change your records from school and things like that. I doubt that. But if you can change it, anything you can change, just change them. Okay?
Okay. So first thing is I need to change it in my passport, right?
Yes. Change in your passport, and then you go to all those units, Social Security for the second, and then driver's license, etc., etc. You keep moving from there. Okay?
Okay. Thank you, Shah.
Okay. Good luck to you. Good luck. Let me call. I think I have Kishore on the line. Hi, Kishore. This is Shah. Hello. Hi, Kishore. Hello. Yes, sir. Can you hear me?
Can you hear me, Mr. Shah?
I can hear you clear. Go ahead. How about you?
Yeah, I can hear you too. Thank you. First of all, I'd like to thank you for your excellent service to the community.
Oh, thank you so much. It's very kind of you.
I just have one question. What are the chances for the I-140 getting affected due to the fact that the beneficiary is on F1 student visa and is on CPT as well, provided that there are a few memos related to the practical training and the unlawful status as well?
Okay, if you're asking the question, how can the I-140 be affected? The I-140 will not get affected. What can get affected is your F1, the other way around. So if you have an I-140, that means you fall into the INA 214B, which is immigrant intent, and it's time to renew your F1. They have a right to deny it. As for the memo, it has not really related to that. How it would be related if there was some kind of places where you fall out of status. But until the government take away the F1, because the immigrant intent, they have not really mentioned this as something that automatically negates your visa. They might use it, we don't know yet, but I don't think they have mentioned that clearly. So bottom line in your case, I think you should just not worry about this part, hopefully. But ultimately, I would like you to see you on an H-1B or some kind of other visa while your I-140 is going on. But the I-140 doesn't get affected, but they can affect the F-1 and down the road if you're renewing it. And we don't know yet until after the August 9th thing if that will be something that trigger a cancellation of the F1. But I doubt it because it doesn't say just an immigrant intent doesn't automatically negate your non-immigrant visa. Only if they make an action against it, then it's different. Okay? Did you follow me?
Okay. Another quick question.
Go ahead.
Like, even if the I-140 gets approved, and given that the student is from the rest of the world category, would it be wise to go ahead with the adjustment of status application?
Oh, definitely. File your adjustment of status application as soon as you can, because you never know when this can retrogress, etc. And the good thing is that once you file it, then you don't have to worry really about the student visa, because what it will give you is called a period of stay authorized by the Attorney General under INA 245A, which basically keeps you legal here and gets you a work permit. So yes, I highly recommend you file your I-45 as soon as possible.
Okay. Thanks a lot, Mr. Shah.
Okay. Good luck to you. Good luck. And thank you for your kind words. One more call I think I have. Sushil, this is Shah. Hello? Hello? Okay, I think I lost Sushil. Sorry for that. So, ladies and gentlemen, please feel free to call. The number to call to the studio is 510-657-1170. 510-657-1170. And if you want a consultation with our office, 510-742-5887. 510-742-5887. And just to let people know, anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. I don't know how much time I have to go, Michael, but please let me know. And now, if you want to call again, the studio number 510-657-1170. And since we were mentioning about the interview that is coming up on most of those cases of I-45, I highly recommend that you kind of look. I have some YouTube videos on those, but these are kind of old. I will try to put a new one. It's not very different, except now what they will do, they will dig a lot into if you change job under AC-21 Supplement J. I just had a client who went there and they submitted a Supplement J and they returned it. Now they are looking for it and say why you didn't submit it. So make sure you file the Supplement J just to be on the safe side. Even if you are not required to do so, at least have it under a record that you file it, because it seems they're asking that. Technically, the Supplement J should have been filed only if you change jobs. But since now they're kind of asking for it, I highly recommend everybody to file it just to be on the safe side. And then again, just to let you know, we also help people a lot with the EB1 cases. This is becoming hot. Even though the dates are not current for India, the dates are still faster than other EB2, EB3, etc. So we highly recommend, if you have an opportunity for an EB1 or an EB2 if you're not born in India. For example, you might be Indian, but you were born in Bahrain, you were born in Dubai, you were born in Nepal, in things like that. You benefit from that. And even if you are not, you are not born there, if your wife is born there, you can use that too. Let me take another caller, Michael. This is Shapra. You're live in air. Hello. 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 Hello, this is Shapra. You're live in air.
Hi, sir. Good morning.
Good morning, sir. How are you?
Yeah, doing good. Thank you. So, I have one question regarding... Hello?
Yes, I can hear you. Go ahead.
I'm not able to hear your voice. It's clearly, so...
Oh, you can hear me? Hello?
Hello?
Hello? Yes. Hello?
I would like to know more on the CSPA, the Child Status Protection Act. So, I heard that under the CSPA Act, certain child, even though they are over age 21 years, they get the green card permanent residency along with their parents. So, could you please give me more details? So, what are the eligibility for the details to get into the CSPA?
Okay, let me tell you how it works. The CSPA is a Child Status Protection Act. For example, let's say you file an I-130 for your brother, and your brother have kids. The I-130, you file it, let's say the kid was 7 years old, and it takes like 12, 13 years to process. I don't know if you're hearing me. Can you hear me?
No, not able to hear you.
Okay, just take the call offline.
Over the radio, so you can continue.
Go ahead. Yeah. So I'm so sorry for that. So basically the Child Status Protection Act, this is a very tricky mathematical thing which is confusing even for us. Bottom line what it is, you subtract the time that you got. For example, let's say you file for your brother and your brother have kids and the kids are 7 years old or something. It takes like 12 years to get it, or 13 years or 14 years, right? Even 15 years. So what happens is if it takes the first part, which is the I-130, let's say it takes like 3 years to reach the I-130, you have a right to minus that 3 years from the case, which brings it from 21 or 22 back to 18 when you minus that, or 19 actually. So the time, only the time that it takes for the first part, the I-130, you can subtract. And it's kind of the same thing for the I-140. It's a little bit more complicated if you have an adjustment of status. So bottom line, you can only minus that little time. You cannot minus the whole 14 years. You can only minus that little time to get the I-130 approved. So I hope this answers your questions. And the Child Status Protection Act, unfortunately, we were counting a lot on this, but the Supreme Court put us down on this. Let me take another caller. This is Shaprai, you're live in air. This is Shaprai, you're live in air.
Hello, Mr. Shah.
Hello. Yes, sir. I'm listening.
Hello, Mr. Shah. Thank you for your service to the community.
Oh, thank you so much for your kind words.
I have a question. I am working for a company A on EAD, which is issued on my I-485 adjustment of status. Now I am looking for a new job, and when I applied for the company B, they are asking if I need a sponsorship now or in the future. So is that, do I need a sponsorship from the company B? If yes, what exactly do I need from the company B?
Okay. What you need is to do something called AC-21 through a supplement J. What it does, it basically moves that green card from company A to company B. There are two requirements for that. Number one, 180 days has passed since the I-45 was filed. And number two, you need to move to a same or similar position. That's very, very important, that part, the same or similar position. Because if you don't have that, then you're going to have an issue. So, yes, you kind of need a sponsor, but it's not really a sponsor. All it is a form. There's nothing, I don't think even there's a fee associated to it. They just have to fill the form and submit it. It's called I-45 Supplement J. You can Google it, and if you need help to do it, you can give us a call. We can help you on that. But bottom line, it's just that you need. It's not really a sponsor, but it is a sponsor because what they're doing, they're basically promising a job for you when you get your green card. Okay? So it is a sponsor without being a direct sponsor. I'm sorry?
So that has to be done by the employer, right?
Yes. Well, you can prepare it, design it, but yeah, it has to be signed by the employer. Okay?
Oh. Okay, great. Thank you very much.
Good to you. And if you need help on that, 510-742-5887. I think I have another call, Michael, right? This is Shapra, you're live now.
Hi, Mrs. I have a question for you. So,
yes,
if an applicant is on H-1B and whose I-140 is approved, and after that, if he changed his company from A to B, C, D, so and so, and then, none of the other company like B, C, D has already filed the PARM, from the initial stage. So is there any chance that government is thinking, or do you have any clue that, PARM for him, the H-1B, status will be revoked, or he will not get his PARM approved? Something like that? Okay.
Let me get it right. You have an I-140 with a consulting company, basically, or
yes.
a company that places you other places, right? Well, the I-140 doesn't get affected. Okay.
So we changed the company from company A to company B. Company B said, like, they will file the PARM, but they have not. Then he changed another company, company C. They also did not file. And another company, company D. Right now, let's say he's in company D. But his initial I-140 is approved from the company A. So does it remain valid?
You can use that I-140 to get extension on your H-1B. But ultimately, to get the green card, you will probably have to do another I-140 with company B, unless it is what we call a merger or an acquisition, full successor in interest. So it's very hard to tell unless we know that, but technically, if it is just a regular company, you're just moving from one to the other, you can still use your I-140 to get extension of H-1B or get H-4EAD, but you cannot use it to get the green card unless you go back to A. So what you need to do, company D will have to file your labor and your I-140 if the dates become current to get your green card.
Okay, and if government is thinking anything, something like, whoever case are hanging like this, that will be kind of dismissed?
I don't know. The government is thinking so much right now, I don't know. But I don't think there's a problem there because you're not doing anything illegal. All you're doing is just moving. And the I-140 has no purpose until the dates become current. Right now, only thing the I-140 is doing is giving you your extension. Okay?
Okay. Thank you so much.
Good luck to you. You're welcome. Let me take another. This is Shah. You're live on air.
Hi, Mr. Shah. My name is Dharini.
Hi, Dharini. How are you?
Hi, I'm good, thank you. I had a specific question about a H-1B renewal, but with amendment. So right now, I have I've already completed close to 9 years of my H-1B, and the occupation that they've applied for is operations research analyst. But now, although I have an electrical engineering degree, master's and bachelor's, now they want to change it to, my attorneys want to change it to electrical engineer as the occupation title. I wanted to know if that would cause any issue, because so far I've applied under a different occupation title and now it's going to be different.
No, usually no, as long as you meet the requirements. But they will ask questions how you just shifted. But then ultimately, I think when you shifted the original time, you showed that you have an equivalency of that. But you still have your original, which is electrical. So if they're giving you a job, you still will be able to benefit from the cap exemption. But be ready for a long RFE asking a lot of explanation. So that's all I can see in this case. But apart from that, no, it is possible to do that. It's okay.
Okay, can I still have the same job duties, but only the occupation title being changed?
No, because when you check,
okay, because the attorney
kind of
was
similar,
that, then I was
it doesn't work this way. You have to match it. It has to make sense. I cannot give you the title of a lawyer and make you work as an engineer, right?
No. The title and the job description still fits in electrical engineer, but I don't know why they chose to apply on a different category last time. So I was a little concerned about that.
Yeah. I am. It's very hard for me to tell, but if it is the right code, then the lawyer is right. But make sure that the job matches the code, because the LCA will have to match the I-129. If not, it's a violation of the LCA. So just make sure that you can check it yourself. The website to check that is called flcdatacenter.com. F like Frank, L like Larry, C like Cat, data, D-A-T-A, center, C-E-N-T-E-R.com. All the codes are there. Just plug in your state and your county, and you will be able to get the information right there. Okay?
Great. Okay. But just the H-1B amendment itself is not going to create any issues, right?
Yeah, it will. If it is not done properly, it's very different because they're not doing an amendment, they're doing an extension. And in that, if it is not matching, anything can be a problem, but it's hard for me to tell until I look at compare it, and that will take a lot of time. But just make sure that it is matching. Check those codes. Check that website I gave you. All the codes come from there. Okay,
great. Thank you so much.
Good luck to you. Thank you. So I think, yes, thank you. So I think I have 5 more minutes to go, Michael, so I will not be taking more callers, but talk a little bit about debt settlement. Do I have one more caller? Okay. So ladies and gentlemen, we were talking, of course, about immigration. Now we're going to change gear. And again, anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. So we are talking a little bit now about debt settlement. This is another thing that a lot of people call us about. If you owe some debts under credit cards, second mortgage, etc., and you need to get clear those, feel free to contact us 510-7425-887. What we do here, we settle those debts. It's not like we do a debt consolidation. No, we basically, let's say you owe $10,000, we actually can take it and make it maybe $2,000-3,000. Just an example. It might be less than that. So it's a power of negotiation. It's called pre-litigation negotiation, and we have done a lot of them. You can check the blog, yourdebtsettlementattorney.com, yourdebtsettlementattorney.com, and you will get more details. We can even help on some second mortgage if the house is underwater. So I will recommend that if you need help on that, feel free to reach out to our office, 510-7425-887. And also, if you have a judgment against you, be very careful, because once you have a judgment against you, they can pretty much garnish your paycheck, basically put their hands in your pocket. They put a lien on your property. They can even put a levy on your bank account, etc. So you need to be careful. Don't just let things sit down there. It will get worse. Unless, of course, you qualify for bankruptcy or something, but we don't do bankruptcy. We just do debt settlement. And again, check yourdebtsettlementattorney.com. Now, before I leave, I have 2 more minutes to go, Michael. I will kind of recap. Today we talk about a lot of things, including the interview for I-45, H-1B visa, L-1 visa, but we also do EB-1, like I mentioned. Please check our website. A lot of people, we just got one approved. I wanted to congratulate our team for that. So far, we have been pretty much in good shape on getting a lot of approvals, and I'm really, really proud of that. We're getting them pretty much on a weekly basis. Thank you so much for the team, especially Sharif, handling all those cases. And you can check more about national interest waivers and EB-1, either it's EB-1A, EB-1B, EB-1C. Just to let you know, the checklist that you see that are published are usually not really always required to get an EB-1. Remember that. And you don't need an employer for EB-1A. You don't need an employer for national interest waiver. So I wanted to thank you all for listening to the show today. And I had Michael with me, and anything I told you today, again, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And I think I have Amit on the line. Amit, are you there?